From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court is dragged into the middle of the 2024 presidential election campaign in unprecedented fashion as prosecution appeals and an attempt to ban Donald Trump from the ballot make so-called lawfare central to the campaign. What does this mean for the credibility of the Supreme Court, and how are the justices likely to handle it? Plus, the Senate leaves town without a deal on aid for Ukraine and changes to border policy. Where does the negotiating stand now, and can this deal get done early in 2024? Welcome. I'm Paul Gigot, editorial page editor of the Wall Street Journal. On our daily Potomac Watch podcast, I'm here with Kim Strassel and Kate Batchelder-Odell. And let's dive in first to this Supreme Court, which is the big issue this week. I know on yesterday's podcast, you talked about the Colorado Supreme Court ruling that barred Donald Trump from that state's presidential ballot. That will be appealed by the Trump campaign, and the court will have to make a decision on whether to hear that case. I think it will do so. But today, let's step back, not just talk about the Colorado case, but consider the bigger picture here and what this means, this case and others, for the Supreme Court, and to have it play such a central role in the middle of a presidential election. Of course, there was the historic case of Bush v. Gore in 2020, which settled the dispute over Florida's electoral votes and vote count. But of course, that came at the very end of things. This is the court being thrust into the campaign from the very start, including in the primaries, and playing just a crucial role. There's the immunity case, presidential immunity from prosecution case related to the Jack Smith, the special counsel's indictment of Trump. Trump has said he should be immune from prosecution from official acts taken while president. He lost that case at the district court level, but he's appealing. Jack Smith asked the Supreme Court to hear that in expedited fashion so he can begin his trial, now set to begin March 4. By the way, that happens to be just the day before Super Tuesday primaries. And the third related case is one the court has already decided to take, which is not about Trump directly, but concerns a defendant prosecuted for what he did on January 6th, and whether the Justice Department stretched the Sarbanes-Oxley statute on corporate fraud to prosecute him for obstruction of an official proceeding. The court will hear that argument in the spring and issue a judgment by the end of June. And this could affect Trump because he's also been charged with obstructing an official proceeding. So with that extensive preamble, Kim, hearing myself talk today, I suspect the justices are not very happy about being thrust into politics in this fashion. What do you think?
Nor should they be, because I want to make a big distinction here. And you brought up the Bush v. Gore case back in 2000. And what I would note about that is that was an accidental case that ended up in front of the court, meaning you had a very close presidential election, and then you had a Florida voting system that essentially melted down with hanging chads and a bunch of impromptu litigation over that. And the court was required to step in and stop an endless revoting and recounting situation. What's very different about what we're seeing now is that the cases that are ending up in front of the Supreme Court, which are highly political and, as you say, happening in the middle of an election, are engineered in that these are people, whether it's the special counsel Jack Smith, whether it's Department of Justice bringing these Sarbanes-Oxley January 6th cases, whether it's the Colorado Supreme Court, who by taking unprecedented legal moves, by stretching the law, as you say, are by definition creating cases that were always likely to land in front of the Supreme Court. And by the way, we see this happen often in the legal area. We have a lot of groups on the right and the left who will tee up a case here or there, hoping that by the nature of it and that it's a good case, that they'll get it up to the high court and it will be heard and there'll be some clarity in that area of the law, hopefully in the way they want it to be. But now we're seeing it being done by political actors. And I think it's irresponsible. I think it's putting the court in a very difficult position, especially at a time when it's been under attack by the left anyway. And polls show that some Americans are losing faith in its neutrality, which is a pity. But this is part of a lawfare movement in the political world. And it's just a very, very concerning turn that we should try not to be having and hope that the Supreme Court can get out of the business of.
Right, Kim. We like to think in a democracy that elections are settled by voters.
We'd like to think, yes.
It has been the case that is the way it's happened, with that one exception you explained, Bush v. Gore. And of course, ultimately, by the way, in that case, the final counting in Florida bore out that the Supreme Court had made the right decision, and Bush did, in fact, win the count in that case. In this case, though, I mean, obviously, if you're going to be struck from the ballot by one state, and there are probably a dozen more where similar efforts are afoot, this could have an enormous effect on the presidential election. So the court, I think, will step in to try to settle this matter and take on the argument made by the Colorado Supreme Court. But the immunity case is also crucial, because if Trump is immune in part or whole, that could affect the indictment, four-count indictment that Smith has brought against Trump on January 6th. And this is not a trivial claim that Trump is making. There's a precedent called Nixon v. Fitzgerald, which the Supreme Court ruled that President Nixon and presidents have absolute immunity for official acts taken while president from civil suits. That was a civil case. Jack Smith's case is criminal. But the question is, does that immunity in part or whole apply to president in a criminal case? And to what extent does that immunity apply if it isn't absolute? And that extent, particularly for acts that are within what the court described in Nixon v. Fitzgerald as within the outer perimeter of a president's official duties. So these are crucial decisions that will determine whether or not there's a verdict in the criminal cases before the election in 2024. And the court is stuck in a very difficult position, because no matter how it rules in these cases, one side or the other is going to be unhappy.
Right. And I think to your point about Nixon, it's important to note no one's arguing that the president is immune for criminal acts he commits that aren't related to his official duties. But it depends on this interpretation of that outside perimeter. So there is here some real questions that the court will have to resolve. But I do think the ironies are many, and they're very obvious. I mean, the left has spent the past year on making a very concerted effort to delegitimize the court. And we've seen, the ethics stories suggesting that everyone's corrupt on the court, and this debate about basically getting the court to create some kind of ethics code. The term that the military would use for that is a shaping operation, which basically means you're setting the conditions there to make whatever the court decides, if you don't like it, just not legitimate and not something that you have to accept. So don't rule that out as a possibility here, which is that the court comes to a conclusion that Jack Smith, that other progressives don't like, and they try to disregard it as basically none of it was legitimate. So this is a really potentially corrosive situation. And I think that counsels a couple things, one of which is that, Jack Smith wants this immediate appeal from the court, but the court's under no obligation to move on his timeline to keep his trial on its trajectory so that this is all playing out during the primaries and so that there's a conviction perhaps before the election. None of that should be relevant to the court going through making its decision. So hopefully they take the time, especially to come to a agreed upon ruling that would be good for the country to resolve these questions decisively. So I think the court's got to take the Colorado case for the reasons you described, but it also needs the time to sort out the immunity question in full detail in a way that hopefully will preclude parts of the public from thinking that it's not legitimate.
Of course, Donald Trump often doesn't help here. He has been given to refer to judges he has appointed as my judges, which, of course, they're not. Once they're on the bench, they're judges for the American people. But Trump, of course, views things always through the prism of his own actions and well-being. And my own view is that he may well be surprised here as the cases go ahead, not just these cases we've described, but others, that the court doesn't go his way. They've already ruled in the past against him in cases involving turning over documents. There was the case involving his business documents where they said that Congress and the prosecutor could get access to them in part. Kim, how do you think the justices will handle this? Will they take these cases? And my own preference would be for 9-0 outcomes in the cases to present a unified legal front to the country.
I don't see, unfortunately, how they can't take these cases. If you look at the Colorado case, for instance, if it passes on that, it is going to be an open invitation for other high courts in other states around the country to follow suit and potentially also strip Trump from the ballot. We've had some state courts that have already said, no, we're not going to go there. But there's litigation in like 25 states at the moment. And now that Colorado has opened the floodgates, I think that if the Supreme Court doesn't step in, you're going to see other ones follow. And they know that risk. Similarly, the immunity case, it's kind of a big legal question, as you mentioned, that is almost begging to be settled in this day and age where we are having all this lawfare. So I think they may well take it. I agree with you that Trump should not be betting on, quote, his judges doing anything on his behalf. As you note, there has been that documents case. Also, they ruled against him when the January 6th committee wanted to get a hold of certain documents that had to do with his handling around the events of that day. And there's been a few other things that have come up in front of the court too, and that generally have not gone in Trump's favor. Now, unfortunately, no one's going to remember that if in the end of the day, the Supreme Court does rule on these questions, which, by the way, in my mind, I think are fairly cut and dry, some of them, and deserve to be overturned by the Supreme Court. But it'll be viewed in a political lens. I can't agree with you more that, we've talked in the past about John Roberts and his desire to maintain the reputation of the court. Sometimes that leads him to dodge big issues or kind of cut things down the middle if he can, because he's thinking more about the court's reputation. I can see the wisdom, though, here, and I think it's very likely that he may try very hard, if they do take these cases, to find those issues where he can indeed try to get 9-0 rulings on some of these, especially the most recent Colorado ruling. The immunity one might be harder. The Sarbanes-Oxley one might be harder. But this one about insurrection, there are so many issues that would be put in front of the court here. He's got a kind of wide field, and it would be good for the court, and I hope the liberal justices know this too, to kind of send some real pushback to the critics of the court by saying, we're not going to be put into these positions, and maybe you should stop trying it.